Thank you so much for all of that. We'll look forward to talking with you in just a little while. What I want to do now is bring in criminal defense attorney and civil rights attorney Mark Begnaud to give us some analysis. Mark, always great to have you on the program. Thanks for joining us this afternoon. This case is a doozy. I mean, it is very convoluted and with lots of facts to follow. But let's just start with one important piece of evidence that we're learning that is coming in, and that is that shell casing. We understand that this is found by a family member of the victims, turned over to authorities. She failed a polygraph test. The jury won't know that she failed that polygraph test. But the defense said there's a chain of custody problem with this because officers canvassed that scene in November when the shootings occurred, didn't find anything. And then 5 months later, I should say, from November till April, suddenly that casing appears, and it according to ballistics tests, is a match to have been fired from a gun that the defendant owns. What do you think about that issue and the court's ruling, please, Mark?
So I think that the court probably got the ruling right, but it doesn't dispose of the issue. So, Julie, you mentioned the issue is chain of custody. There are kind of two aspects to that. First is the aspect that the judge is weighing, which is whether it comes in at all. There is law, and it varies by state, and Kentucky will have its own laws on chain of custody. But essentially, if you can't establish the chain of custody at all for a piece of evidence, then it doesn't come in because you can't prove that it wasn't tampered with, that it's in the right shape. And so that's what the judge was looking at. Is there enough of a chain of custody to get it in front of the jury? And the judge said that there was. But then the second issue of that is that still gets to be raised in front of the jury. And so the defense attorneys are still going to be making those arguments in front of the jury. Hey, we know it came in, but they haven't established that this is exactly what they say it is. Number one, it's found months later. Number two, the whole scene was canvassed at the time. And they'll be asking the officers who canvassed the scenes, did you do a really good job? Did you check everywhere? Are you trained in how to do this? Really establish that they did a really good job of canvassing the scene when they did it. And then all of a sudden, this family member and remember, Julie, the family members before finding the casing had been talking with prosecutors and had been talking with press about wanting to go after Kit Martin for this. And so they obviously have a dog in the fight. And so that's an argument that defense counsel will be making in front of the jury. You can't trust this piece of evidence. It's brought in by a biased party. It was found months later, and the cops did their job when they canvassed the scene in the first place.
Excellent analysis from you, as always, Mark Begnaud. So glad to have you on the show today. Thank you so much. I'm being told that they are taking a lunch break in Kentucky, and things are getting ready to begin in California with the Robert Durst case. So what we're going to do is squeeze in a commercial break right now, and when we come back, we're going to show you an interview with Christian Martin. Don't go away.